Hello, my name is Julia Saladino, and I'm a senior staff attorney with the Women's Law Project at the National Network to End Domestic Violence. I've been with the Women's Law Project for about 6 years and previously represented victims of domestic violence in family law cases. Today, on this online information clinic, I'll be giving a brief overview of the way domestic violence intersects with custody cases. Oftentimes, once someone separates from an abuser, the abuser may no longer be able to physically abuse the victim or have easy access to the victim in order to maintain power and control over them. An abuser may try to keep power and control over the victim if they have children in common. Perhaps an abuser will make exchanging the children for visitation difficult or will harass the victim during these exchanges. The abuser may try to influence the children to favor the abuser over the victim, or may constantly threaten the victim with going back to court and filing motions. There can be many ways that an abuser attempts to maintain power and control over a victim through shared children. So the relationship between domestic violence and custody cases can look a little different in each state. As we've mentioned before in other online information clinics, when a judge makes a decision about custody, they must decide what custody arrangement is actually in the child's best interest. In most states, the judge will consider a specific list of factors that you can actually find in the law when making a decision about what's in the best interest of the child. Typically, these factors are referred to as the best interest factors. Usually, any history of domestic violence or child abuse is actually going to be considered by a judge when deciding what's in the best interest of the child. A history of domestic violence could include something like a finding of domestic violence in a restraining order case or a criminal case, or even in the current custody case if you present evidence on it. I'll talk a bit more about that later. Additionally, in some states, the law may create what's called a rebuttable presumption when there has been a finding of domestic violence in a case. Now, let me take a minute to explain what that means. Generally, a judge will approach a custody case by starting with the position that it is in the child's best interest to have both parents in their life. In some states, the judge even starts with the idea that joint custody is usually what's best for the child. After considering the best interest factors, a judge may actually decide that joint custody or having both parents actively involved in the child's life isn't actually what's best for the child. However, in some states, when there has been a finding of domestic violence, the judge actually starts their analysis from the position that it will actually be in the child's best interest to not be in custody of the abusive parent. This is called a rebuttable presumption. The judge assumes that the abuser should not have custody, but this assumption can be rebutted or actually proven false. The abuser can present evidence that it is actually in the best interest of the child for the abuser to have some custodial rights and access to the child. Presenting evidence of domestic violence in a custody case for the first time is going to be a strategic legal decision that a victim will have to make because it can be a double-edged sword. A judge may question the credibility of the victim if the first time domestic violence is brought up is in the custody case. Also, we know that abusers can be very convincing when they're in front of a judge and other professionals, like the social workers who may be conducting interviews with the children and the parents, or may be conducting home studies in the custody case. Therefore, it's possible that a judge might not be able to see how they can actually also be abusive. Successfully proving domestic violence could impact the judge's decision about who gets custody, and so that's why it's really important to discuss it with a lawyer. A lawyer in your state would be able to give you some advice on how best to prove abuse in your situation. This may be through your own testimony, the testimony of other witnesses. It could be through medical records, photographs, text messages, email, police reports, or other documents that you have. What can be considered in your state is actually going to depend on your state's rules of evidence. So again, that's why it's important to speak with a lawyer in your state, because that's going to be different depending on the state. Another thing to keep in mind is that in many states, the law includes each parent's ability to promote or foster a relationship with the other parent as one of the factors that must be considered when deciding custody. So it's one of the best interest factors very often. This can be particularly difficult in a situation where one parent is abusive. So having a lawyer explain the situation to the judge can be helpful. Some state laws will specifically tell the judge not to consider this factor if domestic violence has been proven. So it's going to be helpful to know how your state addresses a situation like this. Ultimately, a judge may decide that the abuser should have custody or visitation with the child, even when there's been a history of domestic violence. Usually, the judge will need to make a finding that the child can be safe despite the history of violence. In a custody case, you may also be faced with the option of doing mediation. In many states, there are court-provided mediators, and their role is to help the parents to try to reach an agreement about custody and visitation. However, one thing that a victim of domestic violence should consider is that it's not always advisable to agree to mediation. Even though a survivor might be in the process of finding their power and reclaiming their voice, there's usually an imbalance of power in a domestic violence situation, and that might make the survivor agree to do something that would not actually benefit them. Even though the judge may push for mediation, you can object because mediation can put survivors at a disadvantage. If a judge decides it is in the child's best interest for the parents to share custody, even when one parent has been abusive, the judge may actually put some limits on the custody arrangement, and this is often to help protect the other parent and to protect the child. These may be things that you can actually request that the judge include in your order. For example, a judge may order that visitation actually be supervised, or in extreme cases where the judge does not believe visitation will be safe, visitation with an abuser may not be allowed at all. When visitation is supervised, this supervision could take place at a supervised visitation center or by another person, often referred to as a third party. Usually the judge will approve of this third party, and it could be a family member or some other adult. Often, supervised visitation isn't a permanent solution in a custody order. So the judge may order that supervised visitation be evaluated after a certain period of time, or may order that the parents slowly move towards unsupervised visits. A judge could also order that a third party facilitate any custody or visitation exchanges, or that the exchanges happen at some type of safe public place, like a visitation center or a police station, perhaps. Generally, this will mean that there will always be a third party witness while the parents have to interact to exchange the child. Or in some situations, the third party might actually pick up the child from one parent and bring the child to the other parent to ensure the victim's safety. In that situation, the parents wouldn't actually have to interact with each other at all. Another way the judge may try to protect the victim's safety is by ordering that the parents have limited communication. A judge may order that the parents only communicate about the children and related custody and visitation issues. There are also certain parenting apps that can be used to actually log all the communications between the parents and can serve as proof if there's been any inappropriate or harassing communications by the abuser. A judge may also clarify the parents' decision-making roles regarding the child. So, for example, if the judge orders that the parents must share decision-making power regarding the safety and welfare of the child, the judge may allow each parent to have decision-making power over a certain area of the child's life. For example, the mother may be ordered to decide anything regarding education and religious training, and then maybe the father could be ordered to decide things regarding healthcare or something like that. Or the judge could order the parents to try to make the decisions jointly, but include an order allowing the non-abusive parent to have final decision-making authority in the event that the parents just cannot agree. The judge may alternatively order that the parents use some type of third-party mediator or parenting coordinator to make these decisions when they're unable to come to an agreement. In an attempt to limit disagreements or the amount of communications between the parents, a judge could also include additional provisions in a custody or visitation order that schedule when the child is supposed to be with each parent. So the judge, for example, could order which parent the child spends time with on certain holidays, like New Year's Eve or Mother's Day, or birthdays, including the child's birthday and the mother and father's birthday as well. The judge might divide up which parent gets the child on the child's days off from school and during their vacation time. The judge may include specifics about pickup and drop-off logistics of the children. The judge may limit out-of-state or out-of-country travel. And the judge could also order something known as the right of first refusal. This means that a parent will be required to give the other parent the right to take care of the child before using a third person as a babysitter. So this happens, for example, when one parent is caring for the child and all of a sudden has to go to work, or maybe some other emergency has come up. Before calling someone else to come babysit the child, that parent must call the other parent to give them the opportunity to care for the child first. So this is known as the right of first refusal. In some states, a judge may even order some things that can help protect the victim, such as limiting when the abusive parent can contact you or what they can contact you about, or restricting the other parent from negatively speaking about you to the children. Now, I want to take a moment to shift gears and also talk a bit about the relationship between custody cases and restraining order cases, because both can be going on at the same time. A victim of abuse may decide to file for a restraining order to get protection against the abuser. If the judge does decide to issue a restraining order, either after a trial or by consent, the judge generally has the authority to include terms in the order regarding custody and visitation. Any custody and visitation terms included in a restraining order usually last as long as the restraining order lasts. So once the restraining order expires, the custody and visitation order that's included in the restraining order would also expire. For a longer term custody order, usually either parent is going to need to file a custody petition. If there is a custody order in place before a restraining order is issued, the restraining order may temporarily amend the custody order to safeguard the victim and the children's well-being. So this means that the provisions that are included in the restraining order may be controlling in a situation where there's both a restraining order issued and there's also a custody order issued. If there is a no contact provision in your restraining order, generally the restraining order can be changed to allow for exchanges of the child or written communication with the other parent as needed. For example, a judge may include language in the restraining order that states that the abuser cannot contact the victim unless it is in regards to the children in common. So that's an exception that can be included in a restraining order in many states. So that concludes the information that I'm providing today about custody cases and domestic violence. Thank you for joining me today for this online information clinic. I want to also invite you to visit our website, womenslaw.org, where you can find other online information clinics, and you can also write to us on our email hotline, which is a confidential and anonymous way to ask legal questions related to domestic violence, sexual assault, or stalking. The email hotline is available in English and Spanish, and it's staffed by attorneys, including me, on the Women's Law team. Again, thank you for joining.